My name is Leslie Millin and I'm a barrister at Farrar's Building, and I specialise in employment law. I also specialise in personal injury and inquests, but employment law is the major part of my practice. And I wanted to speak to you today about age discrimination and how it's increased since COVID. COVID has forced society to work in different ways, and many businesses have suffered severe financial pressure due to COVID. And reports have actually confirmed that younger and older workers have been the most affected by the pandemic. And age discrimination claims in the Employment Tribunal have increased as a result. Employers will have to evaluate the situation, and if, for example, redundancies become necessary, then a fair procedure must be carried out to avoid, if possible, Employment Tribunal claims of age discrimination and unfair dismissal. This webinar will cover all aspects of age discrimination and will address how employers can try to avoid claims of age discrimination when dealing with redundancy situations and other workplace incidents, which could give rise to a claim, but will also address situations which can arise in the workplace, which would allow an employee to bring a claim of age discrimination using the latest case law. And age discrimination can relate to either an older person or a younger person, and it isn't just confined to older people. So I'll start with direct age discrimination, and this is under the Equality Act 2020, section 13, subsection 1. And direct age discrimination by one person, say A, against another person B, occurs when A treats B less favourably than A treats or would treat others, and A does so because of the protected characteristic of age. And an example of this is in Keane, that's Keane, and Investigo, and that's UK EAT/0389/09. The EAT held that a claimant who applies for a job in which he has no genuine interest, in that he would not accept it anyway, even if it were offered, cannot succeed in a claim for discrimination where his application was rejected on discriminatory grounds because he cannot be said to have been unfavourably treated. And that is, he will have suffered no detriment on account of the rejection. I actually had a case fairly recently in which I was representing the claimant, and the respondent was the employer, and he stated that he actually treated everybody unfavourably, whether it was employees or clients. And he called witnesses to the Employment Tribunal, which included clients, to try to show that he treated everybody badly in the same way. But he didn't succeed in the victimisation claims. There were many victimisation claims, because the people he called as witnesses were actually men, and some of the insults he was hurling at my claimant were actually female-related insults, and so he was found to have discriminated against her because of sex and age. But going back to direct age discrimination, there is the need to make a comparison. Merely treating a worker unreasonably, as I stated, will not amount to direct discrimination if it can be shown that the employer would have treated all workers in a similar way, or, as I've stated, badly. Different treatment is not the same as less favourable treatment. It's important to show objectively that the treatment of the prospective claimant was worse than the treatment of the comparator. And then moving on to comparators, a claimant may compare their treatment with that of a real comparator, or ask the Employment Tribunal to infer that the employer would have treated a hypothetical comparator more favourably. Comparators may be different from the claimant, and provided the difference is not material. Hypothetical comparators do not need to be an exact clone of the claimant in every respect, but, for example, could carry out the same job as the claimant because of a protected characteristic, and that is here, age. In a claim of direct discrimination, it's not enough to show that someone has been less favourably treated. It must also be shown that that treatment happened because of a protective characteristic, and in this case it would be age. And to constitute direct age discrimination, the less favourable treatment must be because of age. The phrase because of covers the following situations: circumstances where the behaviour is done because of the age of the victim, and circumstances where behaviour is done because of the age of a third party, and that could be, for example, the person's partner. This is associative discrimination. And there's also circumstances where the offender thought that either the victim or a third party had the relevant characteristic, but in fact was not in fact true. For example, where the offender was prejudiced against all people in their 60s and believed that the victim was in his 60s and discriminated against him because of this, this would still be a direct age discrimination, even though the victim was not in his 60s or 70s. It can be seen from this that it's important for the employer to have strategies to make their workplaces age inclusive. Frequently, employers do have regard to diversity and inclusion, but they often do not appear to use their strategies for age-related issues. That employees concerned about age discrimination usually resort to issuing employment tribunal proceedings because that's the only relief that they can have. There is justification under the Equality Act 2010, section 13, subsection 2, and age discrimination cases are different to other discrimination cases in that these cases, such as race and sex, the justification defence cannot be invoked. An employer will succeed in establishing the justification defence in a claim of direct age discrimination where it can be shown that the treatment of the claimant was a proportionate means of achieving a legitimate aim. And as stated, you cannot do this with other discrimination claims such as age or sex, such as race or sex. Indirect discrimination claims concerning other protected characteristics, justification is only potentially available against a claim of indirect discrimination, but not direct discrimination. There are two recent interesting cases on justification and its application, and these were considered by the EAT with Mrs. Justice Eady presiding. And these were the cases of Pitcher, the appellant, against the Chancellor, Masters and Scholars of the University of Oxford and another, respondents, and Ewart, that's E-W-A-R-T, respondent, against the Chancellor, Masters and Scholars of the University of Oxford. The issues considered by the EAT were age discrimination, direct discrimination, justification, and discrimination by the employers, and dismissal reaching compulsory retirement age. In a nutshell, Professor Paul Ewart, who was head of the atomic and laser physics at Oxford's Clarendon Laboratories, won a claim of unlawful age discrimination in the Employment Tribunal as he was dismissed in September 2017 at the age of 69. Oxford University had introduced its employer justified retirement age policy in 2011. in a bid to bring younger and more diverse staff into the university. The policy meant that the staff must retire in the September before they reached the age of 68. The Employment Tribunal found the university's policy, which was intended to foster intergenerational fairness, had only created a trivial number of new opportunities for younger academics, forcing older staff to retire, and was not a proportionate method for achieving the policy's stated aims. Professor Ewart, now in his 70s, was delighted with the result in the Employment Tribunal and sought reinstatement to carry out his research projects. The university, however, appealed to the Employment Appeal Tribunal. The appeal was heard with an appeal by Professor Pitcher. So with the first Employment Tribunal, the Professor Paul Ewart actually won his case, but Professor Pitcher, who was also at Oxford University and was also subject to their employment justified retirement age policy, actually lost his case in the same tribunal in Reading, not at the same time, but so he lost his Employment Tribunal claim on direct age discrimination, as the Employment Tribunal had found that the policy in his case was justified, as the policy in his case had created an appropriate amount of vacancies which were justified. The EAT upheld both of the Employment Tribunal's judgments, meaning that Professor Ewart succeeded in his direct age discrimination claim, but Professor Pitcher failed in his claim of direct age discrimination, as the policy in his case was justified. So I think this demonstrates that with justification in direct age discrimination, it can go either way depending on the circumstances. And particularly as both cases were heard in the Reading Employment Tribunal, but by different judges, it does show that this can vary from case to case. So moving on to indirect age discrimination, unlike direct discrimination, indirect discrimination does not involve treating workers differently. Indirect discrimination arises, although the discriminator treats all workers the same, some aspect of that treatment affects one group of workers adversely compared to another. An example of indirect age discrimination would be an employer stating that all workers in a particular post must have at least 20 years experience in a particular area, making it impossible for people below a certain age to be considered to satisfy the criteria. The Equality Act 2010, section 19 provides that A commits an act of indirect age discrimination against another, the victim, and the victim is in the relevant age group, and A applies a provision, criterion or practice, PCP, to the victim, and A applies or would apply the same PCP to persons who are not in the same age group, and that PCP puts or would put persons who are in the same age group as the complainant at a particular disadvantage when compared with persons who are not in it, and that PCP puts or would put this individual victim at that disadvantage, and that A cannot show that the PCP is a proportionate means of achieving a legitimate aim. I was in an employment tribunal once in an indirect discrimination case, and somebody simply couldn't understand what indirect discrimination was. And I think the judge put it very well, in that he said, well, to simplify matters, if you have a group of people and an employer says that only people with ponytails can go into a room and the others can't, then this is indirect discrimination, because it's applying this to a group of people that some people can't comply with that. And then, of course, that would have to be shown why they did it and whether it was justified. But I think that that is a simple and very easily remembered way of putting indirect discrimination. The proportionate means of achieving a legitimate aim is a defence to the potential defence of justification. That defence cannot be raised in response to an allegation of harassment or victimisation. As previously discussed, justification can be raised as a defence to a claim of direct age discrimination, but not to any other claim of such as race or sex. In respect of the PCP, insisting that all workers must have 20 years experience in a particular field, it could be held to be justified and lawful if that level of experience was crucial to the performance of the work to be carried out. And then moving on to age harassment, that's under the Equality Act 2010, section 26(1). And age harassment is subjecting a person to conduct which is unwanted and is related to age, and where the unwanted conduct has the purpose or effect of violating the victim's dignity or creating an environment that is intimidating, degrading, hostile, humiliating, or offensive to the victim. There will be liability if, and this is under the Equality Act, section 26(1)(b), the purpose of the conduct was to violate the victim's dignity or create an intimidating, hostile, degrading, humiliating, or offensive environment, even if it did not, in fact, have that effect, because the victim did not react strongly to the conduct, even though many other people would have done so. So it didn't have any effect on them, but it still is discrimination. The effect of the conduct was, in fact, to violate the V's dignity or create an intimidating, hostile, degrading, humiliating, or offensive environment, even though that was not the purpose of the harasser in behaving in that way. So it could be that the person harassing didn't actually mean to cause the offence, but actually did so. And an example of age harassment would be an employee in her 50s does not have to show that the conduct was done specifically because she is in that age group. Rather, she can potentially bring a harassment claim where, for example, a fellow worker persistently makes unpleasant remarks about older workers in the workplace. For example, that older workers have fading faculties and can no longer do their jobs properly. This actually occurred in one of my cases, which involved multiple claims of harassment by a claimant who I was representing against her employer and fellow workers. And a secretary who was employed by the respondent was actually calling the claimant these types of names and calling her slow and she couldn't do her job properly and this kind of thing. And the respondent was held vicariously liable for her behaviour. And when the judgment was in favour of my claimant, she was held liable. So you have to be really careful with harassment and victimisation. With victimisation, Equality Act 2020, section 27 states that a person victimises another if A subjects B to a detriment, and A does so because B performed a protected act, or A believes B performed a protective act, or A believes that B may do a protected act subsequent to the detriment inflicted. Protected acts relating to the act include bringing age proceedings under the Equality Act. So this is the protected act that people have to do before you can claim victimisation. Bringing age proceedings under the Equality Act 2010, giving evidence or information in connection with any age proceedings under the Equality Act, doing any other thing for the purpose of or in connection with the Equality Act 2010, which is connected with the protected characteristic of age, or making an allegation, either express or implied, that there has been some form of age contravention of the Equality Act by the victimiser or any other person. An employment tribunal, when hearing a victimisation claim, should consider, firstly, they should decide whether the victim did actually perform a protected act, or the victimiser believed they had done or may do so. And then they should decide whether the victim has been subjected to a detriment, and then decide whether they were subjected to the detriment because they had performed, or the victimiser believed that they had performed or may perform the protected act. So in victimisation, the protected act is really important, and sometimes it is very easy to find the protected act, sometimes it isn't. Employers faced with a claim of victimisation could raise one of the following defences. If the age allegation made or the evidence given in connection with age proceedings is false, and the allegation made or the evidence given was in bad faith, where the act of the employer involved in a victimisation claim was a reasonable step to protect its position in the course of defending itself, then that might count for them. And where in taking the action alleged to constitute victimisation, this was not motivated consciously, subconsciously, or unconsciously by the fact that the employer had previously done a protected act, but rather was motivated instead only by one of more features and or consequences of the act, and were properly and genuinely separable from the doing of the act itself. And an example of that is where an employee makes a complaint of age discrimination in good faith, but then makes threats of violence against the alleged discriminator. And with redundancy and age discrimination, this is fairly topical at the moment and is due to, well, not entirely, but is due in the main part to COVID, lockdown, furlough, and everything which has followed. Tribunal claims, as stated, for ageism at work have increased since COVID, and many are related to dismissal and redundancies. In a recent case in which I was instructed, and this was only probably a couple of months ago, it's Mr. D. Edmondson and PCC Limited, and it's an employment tribunal case, and it's case number 2207250/2020. The judge found that the claimant for whom I was acting had been treated unfairly because of his age in the redundancy procedure. It's quite an interesting case because in actual fact, Mr. Edmondson had also brought a claim of unfair dismissal. And there was a preliminary hearing because the respondent said that in actual fact, Mr. Edmondson hadn't actually been dismissed, he'd resigned. And this is aside from the discrimination claim, age discrimination claims. And so a preliminary hearing was held. And perhaps if I just take you through the facts, it may assist. Mr. Edmondson was a telesales operator, and he'd been in the company for around 3 years, and he absolutely excelled. He was the best person, he was experienced. His age was 64 at the time, but he was achieving huge sales and was also being paid commission. And he was in a team of 3 others. There was another woman who was in her 50s, and there was another man who became a comparator, and he was in his 20s. And then lockdown happened and COVID happened, but just before that, Mr. Edmondson had to undergo a serious operation in February 2020, and he recovered. And he went into work in March 2020, just as lockdown was happening. And he had to use a walking stick at the time because he couldn't walk properly because of the operation. And he was seen by a new manager who was actually the line manager of his manager. And she seemed rather surprised and wasn't terribly pleasant to him, but said that because everyone was going to work at home, that she'd have some Zoom meetings with him and get to know him and the rest of the team. But at the same time, she also had employed a new person for the team, making it up to 4. And that person was in his 30s, early 30s. And he hadn't met anybody, but he joined the team in April. So he joined the Zoom meetings as well. So in April 2020, there was the claimant, Mr. Edmondson, and then there was a woman in her 50s, and then 2 younger men who became Mr. Edmondson's comparators. But they had the Zoom meetings for a month in April, and then Mr. Edmondson, much to his surprise, because he was way ahead of the 2 younger men, was furloughed in May, whereas the 2 younger people were not. And it was appreciated that the person who just joined couldn't be furloughed, but the other younger man could have been. So Mr. Edmondson was on furlough, not working, not doing anything. And clients were asking where he was. It wasn't a popular decision. But in July 2020, Mr. Edmondson and the other members of the team actually received letters regarding a possible redundancy situation. And so this is where the discrimination came in. The new manager and Mr. Edmondson's line manager were asked to carry out well, they put the 4 people into the pool, and then they carried out a questionnaire using criteria to see who was best at the job and this sort of thing. The criteria was made by HR, and the 2 managers used the criteria. And at the end of the exercise, the manager, Mr. Edmondson's actual manager, had scored him very highly. In fact, he came top, but her manager, the new line manager, had scored him, and so he came bottom. And he was very, very surprised. And when the 2 scores were put together, it meant that Mr. Edmondson would be made redundant because he had the least score, and also the woman in her 50s. But she had slightly different duties anyway, and it was expected that she would probably be made redundant anyway. And so Mr. Edmondson inquired about it, and the new manager looked at her scores again and decided that she'd alter them slightly, but certainly not enough to affect his position. And so he was then written to in August 2020 and told that he was being made redundant. So it was a rather odd situation because the younger man had already been taken on just before lockdown. And so everyone was struggling to see how there was a redundancy situation. But also because of the potential dismissal, the employer decided to offer Mr. Edmondson a kind of extension to his furlough and told him that he could remain on furlough until the scheme ended. And the scheme actually ended at the end of October 2020, but then was extended. But Mr. Edmondson was written to because he had opted to stay on the scheme rather than accept redundancy in October, and told that that was it. His resignation had bitten, and that was an end to the contract. Well, Mr. Edmondson argued that furlough was still continuing, and he'd been terribly confused in any event and hadn't taken legal advice, and he didn't feel that he had actually resigned. But it was found at the preliminary hearing in advance of the age discrimination claim that in actual fact he had resigned. that part of the case is now with the Employment Appeal Tribunal in the SIFT, but the rest of the claim then continued. So the unfair dismissal component was removed, and the tribunal was now just looking at the other part of the claim, which was the scoring and the age discrimination claim. And Mr. Edmondson was an extremely good witness at the employment tribunal, which was actually held by CVP. And the other witnesses, well, one of the manager who'd scored him highly wasn't called, but the manager who'd scored him badly was called. And on cross-examination, she sort of fell apart because she was trying to say, and the judge was so interested in this that he interrupted and carried on questioning because it was pretty unusual. She said that once she'd got the figures for Mr. Edmondson, that she had applied some kind of percentage which had made it difficult to keep him as an employee. And the judge asked where these figures were. And although everything was in the bundle for the scoring, there was nothing there. And it did appear that this had been sort of made up on the spur of the moment. But in any event, the judge wasn't very impressed with the scoring and found that this woman had discriminated against Mr. Edmondson, and also the fact that she'd taken on this younger man when there was supposed to be a redundancy situation. And she had seen Mr. Edmondson using a walking stick and was surprised. And so it was found in his favour. And Mr. Edmondson, in fact, received almost £50,000 in compensation for this, actually using the injury to feelings and his financial loss. And he found it, and this is one of the issues with redundancy and age. Once somebody has actually been dismissed, it's often very, very difficult for somebody in their 50s or 60s to find another job in employment. And he made lots and lots, he mitigated his loss, he made lots and lots of applications, but he couldn't seem to find any, even though he had got a good track record of telesales, and he couldn't find anything. So eventually he set up his own company and started to go from there. But he had suffered quite an amount of financial loss because he'd also suffered with loss of commission. And so that's the reason why his claim was relatively high. And also there was the injury to feelings, which the judge accepted my submissions on a middle bracket. And altogether, he is quite happy with what's actually happened, but this can turn out not so well. Obviously, cases for age discrimination aren't won all of the time. And it just goes to show, and also the two professors, one could return. I mean, obviously that was on justification, but one could return to his job, but the other one couldn't. And he is obviously in a difficult situation. So employers do have to be very careful. When this Edmondson case was running, I did actually ask them about if they had any policies on equality and diversity, and this company didn't seem to have very much. There's nothing in the bundle, and they all said that they had actually taken courses on equality and diversity, but I don't think the judge and the panel were very impressed by what was said. And so if you are acting for the employer, you should make sure that they do have current equality and diversity procedures. But the other issue related to age discrimination is the fact that companies are often very keen to be very careful with race, sex, disability, etc., discrimination, but sometimes they do seem to not forget, but age discrimination doesn't seem to be given as much prominence as race, sex, disability, etc. And I think employers should be reminded that they really should be careful on what they're doing, because as with Mr. Edmondson, the actual company he was employed by wasn't huge, and £50,000 out of their pocket probably hit them quite severely, but they have paid, and Mr. Edmondson is very happy. So it is a very good idea, if you're advising employers, to make sure that they tighten up their procedures and be very, very careful when they're dealing with older employees, and to make sure that their other employees for whom they're vicariously liable don't make some kind of off-the-cuff remark about, come on, you're slow, or you're not as young as you used to be, because all these comments can actually be taken and used against them at a later stage. And clearly it gives the employee the possibility of bringing the claim. And of course, employees will do if they can't find other employment, because it's their only redress. And moving on from that, the burden of proof in age discrimination claims. Proving age discrimination or any discrimination really is difficult, as it does involve making a finding about a person's state of mind and why they acted in the way that they did towards another. And sometimes they may not even be conscious of the underlying reason, and will wish to explain their reasons in an employment tribunal, obviously stating that they don't involve discrimination. It is unusual to find direct evidence of discrimination, and usually the tribunal's decision will depend on what inference it is proper to draw from all the relevant surrounding circumstances. And this again is really important if you're, well, whoever you're advising. If you're advising employers, then you have to advise them to be very careful in what they're doing, to show that they weren't unconsciously discriminating with, in this case, age. And to be very, very sure with their evidence and what was happening. The Equality Act 2010 provides a two-stage process for dealing with the burden of proof, and it applies to any proceedings relating to a contravention of the Act, and that's the Equality Act 2010, section 136. And stage 1 of section 136 states that the tribunal must consider if there are facts from which it could decide, in the absence of any other explanation, that a person, i.e. the respondent, contravened the provision concerned. And stage 2 is that if stage 1 is satisfied, then the tribunal must hold that the contravention occurred, unless the respondent shows that they did not contravene the provision. And this is also the kind of two-stage procedure in the burden of proof, because when employment tribunals are taking evidence, if the claimant is making a claim of discrimination, in this case age discrimination, they have to convince the employment tribunal that the discrimination actually happened, and this comes from their evidence. And then, but if they don't convince the employment tribunal that there was discrimination, then the burden won't pass to the respondent employer, because the tribunal will find that it wasn't, the burden of proof wasn't high enough to pass. They didn't find that the evidence was good enough from the claimant to allow it to go over to the respondent employer to make the explanation. But once it is satisfied, then it is a lot more difficult for the respondent to show that it didn't contravene the provision. So that is what happens with that. And then finally, I was just going to revisit remedies. And really with discrimination, age discrimination, sex or whatever, you would get, if you were a claimant and you were successful, compensation for financial loss and injury to feelings. And I think I've already covered that in the Edmondson case. So whatever financial loss you suffer, of course, you've got to mitigate your loss. But for example, if you lose out on commission, for example, you can add that into financial loss of salary. And then the injury to feelings, again, it depends how much you're affected by the discrimination, but that can actually quite substantially increase the award. So that is the end of age discrimination. I hope that you found it interesting, and if there are any questions, then please ask.